Now, thank you. This bill has been in products in the mail for the past 3-4 years. Now, after I went through consideration is the stage where we actually do the enactment, what we call the enactment, where we fix the law. A should be here, B should be here, T should be crossed, I should be dotted. When that is done, it is taken to the third reading and passed. But there's a provision in our law, in our standing orders, indeed. If I may refer to our standing order 171, 1, with your permission, if I may read, second consideration of bills. Order 171, Rule 1 of our standing orders is to the effect that where a member intends to delete, amend, or introduce a provision in a bill which has been passed through the consideration stage, the member may immediately before a sponsor rises to move the motion for the third reading of the bill, move that the bill passes through a second consideration, either wholly or in respect of a particular part or parts of the bill or some proposed new clause or new schedule. So based on this provision, the Honorable Appenyo Market proceeded to bring back consideration. That's how we call it.
I see.
So you bring back consideration and we do what we call second consideration. And Speaker granted him the motion. Now when his motion was granted, then we proceeded to Rule 4 of the 171, which is to the effect that where a bill has been ordered to pass through a second consideration in respect of a particular part or parts of the bill or some proposed new clause or new schedule, the House shall consider that relevant provision and any amendment which may be proposed to the bill. So the Honorable Majority Leader, as he is now, was given opportunity to now bring forth all the amendments he intended to make at this level. And so an addendum, what we call an addendum, is that if you have an order paper such as this and there are fresh matters, the table office will go and prepare those and on the order paper. So we can have order paper, then we have order paper addendum 1, addendum 2, depending on the exigencies of the matters. So he came back with about 15 proposed amendments, which was carried on the order paper addendum. Now, the nature of the amendments was such that Professor Josiah taught us that we shouldn't say something is the same in law. We say they are similar. So the nature of the amendment was such that they were similar. So once the first one failed, consequentially it affected the fate of the other 14. So he was given the opportunity to move the first amendment. It generated debate. He had like 15 minutes to defend it, which was very unusual. But when the question was put, the generality of the members, except himself, voted against it. So Speaker gave him a cue that Majority Leader, given the sense of the House, gauging the mood of the House, it appears that your amendment, the rest of your amendment, may suffer a similar fate. So you may want to do the needful. Again, he made long submissions, but he withdrew the subsequent amendments voluntarily. He refused to use the word voluntary, though, but he withdrew them as a result of the mood of the House at the time. And then we also came back with the sponsors. We came back at the consideration stage, looked at some other sentencing regime and reduced them, and then we moved to the third reading, and the bill was read for the third time and passed. So this is the history behind the sentence. You see, it's also because our defense was that if you say that the conduct that we are proscribing shouldn't come with custodial sentence when a person is convicted. The law, in our jurisprudence, we have what we call in our criminal jurisprudence repeat offenders. the courts frown on repeat offenders.
Recidivism.
Yes, recidivism. The courts frown on that. So once you are just finding the person, the law ties the hands of the court to the extent that they cannot impose a custodial sentence. The person will be returning every other day with the same offense. And the courts will not countenance that. So we give them opportunity to impose a custodial sentence where we have repeated offender or recidivism. So these are the principles behind that. It's not as if we are saying that necessarily the person must be put into custody for the conduct. No, that's not the point.
Right. So I just wanted that at least that's how it ended. Yes, if you conclude on your point.
So Alfred, in all of these, there are other citizens who believe that they cannot have a voice on the floor of the House. You understand? Fairly, they wish they are there to also make their point. But they cannot have their voice. So the only place they can also go and sort of share contrary views to some of the points Honorable Dafemopo is making is in the court. I think we should allow them. But in doing this, what we should avoid is to try and let everybody who tries to help refine this law that we all agree to. I agree to it. I support it because, like I said, I do not want anybody close or far from me to be engaged in homosexuality. So I support it. But most importantly for me, it's a law that would block advocacy. It's a law that will prevent people who will be promoting this, because I don't want my child to go to school and begin to be educated that even though you are male, you can decide to call yourself female. Or even though you are female, you can decide to call yourself male. Women and men, our relationship is from Adam. And Adam is believed to be the first man on earth across religions, if I may be wrong, but that is what it is. And we find solace in each other. Women find solace in us. Women, we find solace in women. And I don't think that in 2024, anybody would want to change that for their child or for their mother or for their father. But we need to tread cautiously as we pass the law, so that we pass a law that's, just as we've done in Parliament, consensus, everybody agrees to it, all politically divided, we all agree to it. Let's pass a law that everybody believes that this law would be beneficial to the entire citizenry. And that is why we don't have to necessarily rush and pretend as if today, for example, if the law is not passed today, it doesn't mean gayism is allowed. There's a law already in existence that abhors gayism, and that is against anybody engaged in gayism today. Even though the Anti-LGBTQ law hasn't been passed. Today in Ghana, you cannot engage in gayism.
Except it's just a sex.
Exactly. You understand? Even today in Ghana, you cannot engage in, let's say, man-to-man or woman-to-woman sexual
That's the
activity.
unusual kind of knowledge.
Exactly. So to answer your question specifically, the MPP and the NDC, they promoted this bill, and so we are in this together. The president hasn't said whether he is or he is not going to assent to the bill, because he hasn't gotten there yet. It is only when it's submitted to the president and he's received it that question would even come in. What is happening now is that a citizen of the republic has gone to and stop the president and parliament from passing the law. The point that Honorable Speaker of Parliament made in reference to Honorable Dafemopo's case, and he's here, maybe he can clarify. After the 20th of March, that Right Honorable Speaker of Parliament made that pronouncement and flew back to Ghana. And by the way, it's paid by the people of this country. Flew back out of Ghana. That point when was being made, Honorable Dafemopo's case was actually not there in the court.
Well, that's another
because
issue
calm down.
Yes, the plaintiff is here, so he will respond.
No, but you have a search report from the court, so maybe the courts are lying.
No, it was.
I am
don't worry.
Calm down. Calm down. The injunction. You can file a case in court, but his application for the injunction was done on 21st of March. But the Speaker of Parliament made reference to that.
Yes,
that when it didn't exist.
Yes,
you understand. It's something that we need to put on record. That the Speaker of Parliament made reference to an injunction by Honorable Roxanne Dafemopo, which was not present at that time. It was the next day, apparently, probably, when the Speaker had actually committed that error, that maybe Honorable Roxy, because Honorable Roxy's application was received at the court at 11:05 a.m. on 21st of March.
It's actually 10:05.
No,
As at
10:15.
as at 9
not 11.
As at 9 a.m. As at 9 a.m., the search report that I have seen that was made in the court, he had not filed anything.
Okay.
And yet, a night before, the Speaker of Parliament was making reference. So maybe they went for an NDC meeting.
But is it not curious? It's interesting.
There was one in 2020. He didn't reference Sky case. There was a case already in 2023. There was a case already in 2023.
You make that reference, you'd also be reminded of what the president said.
No, it's not true. No,
when he met the diplomatic community as well.
Alfred, you are wrong.
You know, so
you are wrong.
Let me bring
you are wrong. There was a 2023 case.
But that one, the injunction had been thrown out.
You are wrong.
The injunction had been thrown out.
No, that injunction was thrown out last week. It was thrown out last week.
It had been thrown out. It had been thrown out last week.
Last week.
I'm telling you, no. It's false.
What you said is false. It was thrown out last week.
When you speak, when we speak, we listen to you, even though we disagreed. So allow.
No, but you're not the
hold on, gentlemen.
So ask him.
No, let me.
I have the thing here as a matter of fact.
I invited, gentlemen.
It is here.
I invited Nelson Roxy Dafiamepo in at a point to clarify that issue of the custodial sentence. Now, let me also acknowledge the presence of yes, you are coming there. Acknowledge the presence of Justice Shemsai, his private legal practitioner, and then also a lecturer. A lawyer, Justice Shemsai. Good morning. Welcome to Key Point.
Good morning, and good morning to my colleagues in the studio. Good morning to everyone. I'm happy to join you this morning.
Thank you for joining us. And come back to you, Nelson Roxy Dafiamepo. There are a few things I want to clear up. Yes. When the clerk did the cleaning of the bill, after you approved it,
yes,
does the cleaning affect the material or have any material effect on the content and nature and structure of the bill before it is transmitted to the presidency?
At all. To answer you directly, at all.
If you say at all, what do you mean?
The editorial work done by the clerk does not affect the content. Now, this is what happens. Let me reference you to our standing order 175, rules 1 to rules 9 on the matter. But importantly, the head note for order 175 is authentication and certification of bills. The background is that in the 7th Parliament, you know, I've been a keen participant in lawmaking, so I've come to appreciate this. During consideration, there are amendments that you move. It will generate debate, heated. Eventually, it will be passed. Now, you can discover that when the law is eventually assented to, gazetted, and numbered, that particular amendment may not reflect in the law. You understand what I'm saying? Or the entire amendment may not have reflected in the law. And if you look at our lawmaking process, it was a lacuna in the procedure that we dictated. So in fashioning the new standing orders, we decided to introduce that as part, just like winnowing. Winnowing is when there are so many amendments to a legislation, like the new Land Act. It's voluminous, and a lot of people are interested, so they bring a lot of amendments. When that happens, you can't do that on the floor. It takes forever. So a small committee of us, about 4, 5, 6, 7 committed members, will sit at deep of night, reconcile all these hundreds of amendments, and agree. And so it's called winnowing. Yes. So we winnowing the amendments. We sieve the chaff from the grain and bring the most material amendments back to the floor. When that happens, it goes through consideration easily. Even though you may not feature in the standard procedure that the laws go through, winnowing is such a critical part under the stage we call consideration.
Okay.
So is this. Authentication and certification of bills. As soon as a bill is passed by Parliament, The text of the bill, as passed together with the explanatory memorandum, shall be sent by the clerk to the government printer. 2. The government printer shall print at least 4 copies of the bill on vellum paper or on a paper of enduring quality and return the copies to the clerk. These are constitutional language. 3. The clerk shall, on receipt of the copies, ensure that the text compares correctly with the bill as passed, and if the clerk finds the copies to be correct, sign a statement on each copy as set out in the Form 1 in the 7th schedule, and the authenticated copies shall be sent to the president for assent. All right? Now, so this stage, you deal with the editorial, you cross T's and you dot I's.
That's fine. I just wanted that because of the point that Dennis Miracles made, that some of you have not even seen the final bill, which was to be forwarded to Parliament, because some changes would have been made that you are not aware of. So I wanted to find out if the work of the clerk affects the content, the material aspect of it. It does not.
The clerk has no such power.
Okay,
to do
great.
That.
I want to move to the next issue.
Now, the second point I want to make is this is the original bill as we submitted to Parliament. With the amendment, it contains 25 provisions on a 21-page document. This is not the same thing that has come out of Parliament.
Exactly.
It's been baked.
Yes, exactly.
This is the raw bread that went into the oven.
the point.
What has come out is the baked material.
Exactly.
Now, the issue regarding this matter, and I want to offer some education here. Dennis got it wrong because, you see, in respect of private members' bill, which is not a government-sponsored bill, the procedure provided by the Constitution is different. The Constitution in Article 106, where are you? Yes, this is Article 106. 106.12 is to this effect. The provisions of clauses 7 to 10 of this article shall not apply to a bill certified by the Speaker as a bill to which the provisions of Article 108 of this Constitution apply. And accordingly, the President shall give his assent to any such bill when presented for assent. What does Article 108 say then? It says that Parliament shall not, unless the bill is introduced or the motion is introduced by or on behalf of, the President, A, proceed upon a bill including an amendment to a bill that in the opinion of the person presiding makes provision for any of the following. Now, when a private member introduces a bill and the member presiding, which in this case is the Speaker, determines that this is not a bill that will occasion a charge on the consolidated fund, and is taken through the processes of legislation and is passed, the requirements under Article 106.1 up to 7 is not applicable. I am not saying it. This is what the
7 to 10 or
yes,
7 to
7
10.
to 10. It's not applicable. This is what the Constitution is saying. Now, it therefore means that there's an imperative, it's a command on the President to receive the bill as passed for assent. That, for me, is the position. So, what is the issue? The issue is that the private members' bill, and Dennis was harping on the fact that this is a joint effort of NPP and NDC. He wants to hear things. We are 8. Only in Team 4 Joe survived. And he survived. He survived on principle.
But is he NDC?
There were other sponsors.
What is your point?
You see, my point is that belatedly you want to take glory in the
Success has many parents.
but I'll leave that for you. I'll leave that for you. So I am saying that the president, we've all looked at the law. The bill as it is, technically speaking, legally speaking, is not yet an act of parliament. For anybody to say that I am questioning the constitutionality or legality of an act of parliament, properly so called, that is assented to, gazetted, and numbered properly by the clerk to parliament, and is being rolled into implementation. That is only when you can go and question the constitutionality. But as it is, we are sponsored. Do you know we can go and withdraw it? We can go and move a motion and withdraw it. Yes. So it remains a mere intention. But I won't sit here and make my legal arguments because there's a forum convenience for that. But your question that you're asking is the confrontation between the executive
And
the
in the legislature, for that matter.
What has occasioned that? What has occasioned that is the fact that language, arrogance, incompetence is what has occasioned this. Why? The president says that I will not even receive a constitutional function that is mandated upon parliament. I will not recognize it. Submission of a bill passed to his office is part of the functions of parliament. Now there may be a suit pending in respect of this matter, but the receipt of the bill, in my humble view, cannot be contumacious of the powers of the court to make a determination of the case on its merits. How does that prejudice the outcome of the case? Unless we are saying that parliament is stopped from performing its functions. And here we have a lot of authorities by the same Supreme Court that says that you can't do that. And let me seek your leave and refer to this very formidable case. In Amidu versus Kufuor, the Supreme Court had the opportunity to say this. And this was the opinion wrote by Justice Berger. It says, our constitution, like the American Constitution, is a written constitution underpinned by the doctrine of the separation of powers. And it is important to say that being a written constitution, it has, like the American Constitution, certain fundamental or basic attributes. The first is that the people of Ghana voluntarily, in the words of the preamble, do hereby adopt, enact, and give to ourselves this constitution. And under the constitution, the people of Ghana have exercised their natural and inalienable rights to establish a framework of government. The second attribute is that the form of government envisages three important branches or arms of government. That is the executive, legislature, and judiciary. The third attribute is that these various departments of government have their respective powers laid down with limits not to be infringed or transgressed by any arm of government. But these limits, expressed in a written constitution, will be meaningless and serve no purpose if freely ignored or infringed by the organs intended to be restrained. Although power is dispersed among the various organs of government, it should not be at the expense of harmony and governance. And I stress this, there is inherent or internal evidence in our constitution that the policy which informs or should inform an act and the desirability of enacting such a law are matters for the executive and legislature to decide. But the interpretation of the law, its enforcement, and matters relating to the validity of the law enacted by Parliament fall within the judicial functions of the courts. So that when we decide the validity of an act of Parliament, we are not descending to the well of Parliament and thereby interfering with its work. We are empowered by the Constitution to declare if Parliament transgresses the constitutional limitation placed on its legislative powers. These are the clear provisions of the holding of this decision. Now, into 4 versus the Republic. All right?
The Attorney General.
Attorney General. The courts, again, the Supreme Court is very clear that where the Constitution says Parliament has the power to do certain things, the Constitution has not been able to provide the formula for doing so.
Okay.
So when the Constitution in Article 110 is giving power to enact regulations to govern its own procedure, how it does it is a matter of closed book. So, for instance, you cannot say that you want to question how the member presiding exercises that opinion in declaring that a bill will not occasion a charge on the consolidated.
But the fundamental issue that has been raised by the person presiding's position is that aspect of the statement he read, which borders on your suit, on the interlocutory injunction. I want us to move and progress with this conversation because of time. Now, we have aspects of the Speaker's statement I'm going to put on the screen shortly. He indicates that, quote, "Be that as it may, honorable members, I also bring to your attention the receipt of a process from the courts titled Roxanne Nelson Eche Dafiameko versus the Speaker of Parliament and the Attorney General, suit number J112-2024. Which process was served on the 19th of March, 2024, and an injunction motion on notice, seeking to restrain the Speaker from proceeding with the vetting and approval of the names of the persons submitted by His Excellency the President until the provisions of the Constitution are satisfied. Until the provisions of the Constitution are satisfied. In the light of this, the House is unable to continue to consider the nominations of His Excellency the President in the spirit of upholding the rule of law until after the determination of the application for interlocutory injunction by you. Yeah. You are the plaintiff in this case. Yes. After this statement by the Speaker, the Attorney General and Minister of Justice, Godfrey Adame, had cause to go and conduct a search at the court registry to establish whether indeed there was an application of interlocutory injunction by you. And he indicates in the statement that he issued that as of 9 a.m. the next day, which was the Wednesday, there was no record of any Thursday for them. There was no record of any interlocutory injunction application by yourself. Then we got a copy of your suit. Now, take a look at this. We established that based on the face of the document that we received, your suit was filed at 10:15 a.m., the same day that the Attorney General conducted the search at 9 o'clock. Now, thus, that legitimized the position of the likes of the AG and what Dennis Marcos Abati has said today, that as of the night before or the evening before, that was Wednesday evening, the Speaker was making this statement, there was no application of interlocutory injunction by yourself.
Okay.